Welcome to Sectional Titles with STBB. I'm Rivka Hoyi. It's very important to understand what it entails when you buy, live in, and manage a sectional title scheme. It's very different to living on your own in your own freestanding property. You're co-owning and living in close proximity to many strangers, and you're co-owning common property with these strangers, and it's very important to understand what all of that means and what your rights are and your responsibilities to your neighbor and certainly to your asset. To make all this coexistence harmonious, it's very important that rules are established in each sectional title scheme to ensure that everything flows, that the asset that you've paid quite a large sum of money for is maintained and looked after, and that everyone follows the procedures so that, just to avoid any unnecessary dramas in sectional title ownership. So as a result, legislation provides that all registered owners of sectional title units form a body corporate. That body corporate is responsible for everything on that scheme. You as an individual section owner, you're responsible for the interior of your section. So you have to ensure your contents, but everything outside your unit is insured by the body corporate. So if you're in an apartment block, that lobby, that lift, the grounds, everything gets insured, and you all as registered owners co-own that responsibility, and you're liable for the cost of that insurance. So too, you're responsible for the security of the property. Whether you have a security guard or you've got armed response, you've got an electric fence, you've got to share in that responsibility. So how do virtual strangers who are just form this body corporate end up actually managing and running what can be a really big complex, or it could be really tiny? You could live in a complex of 4 units, but how do you actually not only co-own, but manage and run and make sure that everything gets paid the way it's supposed to? Legislation, the Sectional Titles Act legislation provides that the body corporate amongst themselves have to appoint trustees. So amongst yourselves, trustees are appointed to attend to the day-to-day on behalf of the body corporate. Ultimately, the body corporate is still responsible, but you certainly entrust the management and affairs to a handful of you. Among the trustees, they then elect a chairperson. So one of you is the chairperson of the body corporate. Most people who own in sectional title or even live there don't have the know-how as to how to run and manage a whole block or huge piece of land, and they might not be financial gurus either. So what happens is they're allowed to outsource some of that responsibility of the admin and the finances to companies called managing agents. Despite mandating a managing agent to collect levies, for example, and run with the admin and making sure that the gardening service is popping at the property whenever they're supposed to, the body corporate remains ultimately responsible for everything to do with the running of that scheme. It's very important to understand that, because when clients come and consult with us, there's usually the defense that, oh, it's on the managing agent or the body corporate or my trustees. You as the registered owner, you have to be reading your minutes of your meetings. You have to keep on top of what's actually going on in your scheme, because ultimately, as a member of the body corporate, you are liable for anything that happens on that common property, besides, of course, being liable for whatever happens within your own property as well. We've often received queries about Airbnb and short-term lets. It's important to check your rules. Part of running a scheme really, really well is that the Sectional Titles Act imposes a condition that every scheme has to have registered rules. There are management rules and conduct rules. The Sectional Titles Act provides for a standard set of rules, which a developer can certainly register when he registers the scheme, or he can contact his STBB conveyancer to create a bespoke or customized set of rules for that particular development. It might be a really small development, so you don't need the full list of sectional title conditions, so you want quite a nice bespoke group of rules that so that it works for that specific small complex or a large one. If you at any point have your own customized rules, or if you amend the standard rules over time, all of those amendments or customized rules have to go past the desk of the recently created sectional titles ombud. The role of the ombud is to make sure that sectional title body corporates and managing agents are running their schemes in a fair and reasonable manner. So the role of the ombud is to just check those rules, make sure that whatever you've come up with is fair and reasonable. They give it their stamp of approval, and you can go ahead and then register your amended rules or your customized rules at the deeds office. Once those rules are registered at the deeds office, they're then imposed on all the owners, and everyone would have to adhere to them. If rules want to be amended over time or in future, at a meeting, a special resolution is passed by the members of the body corporate, and then the amended rules would be adopted, and so those changes get registered at the deeds office as well. Airbnb is quite contentious. Most people want to, make extra money with regards to short-term lets, but you have to look at the rules of your scheme to make sure if you're allowed to do short-term lets, if Airbnb is allowed, if pets are allowed, or specific types of pets, maybe cats are allowed but not dogs because of their barking. All sorts of rules vary from scheme to scheme. No two schemes are alike, so you really have to check, and don't rely on old rules. Certainly ask the managing agents or the trustees of the body corporate for the latest rules, because as I said, those could be amended over time, so it's very important to check that. We also get asked about the liability of body corporates. Who's responsible if someone walks down part of the common property and someone slips and falls? What is the responsibility? A body corporate has vicarious liability. So even though a body corporate is not one individual person, it's made up of a body of people. So the body corporate as an entity can be sued for damages should something happen on the common property. And that's very important to understand. As a registered owner, you'll have a responsibility to make sure that your block is well maintained and safe, because of course there could be third parties or even owners that could get injured on the property. There was quite an interesting case in 2013 of Deploy versus Cascades, and in this sectional title scheme called Cascades, Mr. Deploy was a registered owner. There were only 4 units in the development. He was 8 units. Sorry, he was a registered owner. He was also, by extension, a member of the body corporate, and he happened to be one of the 2 trustees. In that scenario, the managing agent at the time was employed by the body corporate, but they also outsourced the gardening and maintenance to a separate company. Mr. Deploy wasn't happy with the gardening service. He himself ran a similar service, and so as a trustee, he terminated the services of the garden service, and he took on that responsibility with the full support of the body corporate. His responsibility was to maintain the common property. And one day, Mr. Deploy himself slipped and fell on slippery moss, which had accumulated in the washing area. And he then sued the body corporate as well as the managing agents for negligence and for his damages, even though he was employed and entrusted to maintain the property on behalf of the body corporate. The court found that neither the body corporate nor the managing agents were responsible for the following reasons. A body corporate, even if it outsources responsibilities to a managing agent or it outsources responsibilities to private companies, the ultimate responsibility lies with itself to ensure that the block is secure and maintained. However, the court held that a body corporate, by its very nature, was not human, so it had to outsource to a person who could fulfill its duty of maintenance, and it had fulfilled its legal obligations by entrusting and employing a reputable company, which was Mr. Deploy's, to actually maintain the property. And he hadn't necessarily done that, so the body corporate was not liable. The court also found that the managing agent wasn't liable because the managing agent receives administrative responsibilities and the responsibility to collect finances, levies that it collects on behalf of the body corporate. The managing agents are not on site. The managing agents don't have an extended responsibility to maintain or to oversee what the condition of the site is and the buildings and the grounds. So the managing agents were definitely found not to be liable, and as a result, Mr. Duploy's case was dismissed. But it's important, I bring it up because it's very important to understand what your role and rights and responsibilities are in sectional title. And if you're a trustee, don't take on that responsibility lightly either. Certainly, when you're thinking of buying in sectional title, when you're thinking of selling a sectional title unit, when you're contemplating becoming a trustee, or even if you're a managing agent who's been asked to assist to attend to some of the administrative responsibilities with regards to any sectional title scheme, get in touch with one of your STBB conveyancers, consult, obtain the best legal advice before you undertake any of these responsibilities. Thanks so much for listening. For more information, visit stbb.co.za.